Construction Company and Equitable Resources, which I'll refer to together as EQT. This case started in 2006 with a class action litigation against EQT alleging breach of oil and gas lease agreements. Settled in 2010 pursuant to a final settlement agreement that included representations and warranties of valid leases. In 2017, the Huey plaintiffs, the appellees, filed a state court action alleging that their lease was actually invalid at the time of the settlement, and therefore EQT was trespassing in the ensuing years. And so the issue on appeal is whether the settlement agreement precludes that state court trespass claim.
I'm having a little trouble understanding your argument, and it's the purpose of the question. You help me out. What's your argument that a trespass claim is a royalty claim?
So the two answers to that. The first argument is that the Huey plaintiffs did not assert a standalone trespass claim. They asserted trespass within a royalty claim, the breach of the duty of good faith. That's the way they pled their claim. We could speculate as to why they did it, but that's what they did. So we think the trespass claim is a royalty claim. But really the more fundamental point is even if the trespass claim is not a royalty claim, it's in breach of the representations and warranties, which are not limited to royalty claims. And so that's a violation of the settlement agreement that we believe triggers the exceptions to the Anti-Injunction Act. So
your contention is the trespass claim here is not a standalone claim?
That's correct. In the complaint, the Huey plaintiffs alleged their trespass claim within a breach of the duty of good faith. And that's in their state court complaint. That's why we don't think that that they've asserted is actually itself a royalty claim. But back to my previous point, the larger point that we are raising on appeal is that we believe that the trespass claim is in breach of the representations and warranties. And so the two high-level issues that we think have to be answered is first, whether the Huey plaintiffs are class members, and second, whether they're in breach of the representations and warranties triggering the exceptions to the Anti-Injunction Act. We think the district court decided both of those issues incorrectly. On the first issue, class membership, the settlement agreement is fairly straightforward here. There's 3 settlement subclasses. The flat rate subclass is defined as any person who entered into a flat rate lease with EQT or its predecessors and then actually received or was due to receive royalties. So there's the 2-part definition. Either you actually received royalties or you were due to receive royalties. And there's no dispute that the Huey plaintiffs actually received royalties, so they fall within the subclass definition. The district court misapprehended this point because it accepted the Huey plaintiffs' argument that if they could convince a state court jury that their lease was invalid at the time of the settlement, that they would not be class members after all. But that ignores the subclass definition, which makes them class members on account of having actually received royalties. So that's the first assignment of error in the district court's opinion. And then as far as the exceptions to the Anti-Injunction Act, there's 2 exceptions that are applicable here, the native jurisdiction exception and the relitigation exception. Between the 2 of them, the native jurisdiction exception is the broader one. That applies to both pending claims and later filed claims. And the district court erred here because it interpreted the exception narrowly and said it only applies to pending claims. So the district court said because the federal action was already decided at the time that the state court action was filed, that the exception could not apply. But that's not the law. The native jurisdiction exception does apply to later filed claims. And in American Honda, which is the leading case on the native jurisdiction exception, this court upheld the applicability of the exception to later filed claims. So that's an additional assignment of error in the district court's opinion, this idea of a temporal limitation in the native jurisdiction exception.
As to the Hoog lease, which I think is in question, what do you do about the abandonment and cessation clause? I take it that Huey plaintiff's claim is that triggered the cessation of the lease.
So I think the problem with their argument there is this is a flat rate lease. And so this kind of lease, as long as the flat rate royalty payments are made, and there's no dispute that they were, there wouldn't be a cessation of the lease based on failure to pay royalties. And so I think that's the first thing is the cessation clause doesn't come into play with this flat rate lease. And then the other issue is their argument kind of ignores the fact that they entered into this settlement agreement that attests to and effectively ratifies the validity of the lease as of the settlement date. And so for them to come now and say that 7 years after the settlement that they think the lease is invalid, the time for them to make that argument was before they entered into the settlement with the representations and warranties that they held a valid lease as of the settlement date. So that would be our response to that issue. And that ties in with the other exception, the relitigation exception. That exception applies to preclude claims that were either presented before or that are foreclosed by agreement. And we believe the representations and warranties of a valid lease as of the settlement date foreclosed by agreement, a later claim that the lease was invalid at the time of the settlement.
I'm still a bit confused. I thought the settlement date was temporarily designated, and the end of that period was December 8, 2008, and the entry they claim constitutes trespass was in 2013.
Correct, but their trespass theory is predicated on an idea that the lease became invalid during the period covered by the representations and warranties. So they're not saying the lease became invalid in 2013. They say the lease became invalid in 1987 or in 2004 to 2005. Those are the two periods they point to for the invalidity of the lease. And those periods are covered by the settlement, which, as you mentioned, goes to 2008. So it would be one thing if they were saying the lease became invalid in 2013. But they're saying that the lease became invalid before they entered into the settlement that attests to the validity of the lease as of the settlement date. So that's the problem with their argument there. And the district court, it said that it didn't accept this argument because it said that the representations and warranties were not squarely presented. But we think that ignores what this court said in Keith v. Aldridge, which is that claims that are foreclosed by agreement are precluded regardless of whether they're formally presented. And in many respects, this case has a lot of similarities to Keith v. Aldridge, where there was a settlement of claims, and then subsequently the plaintiff tried to bring an additional claim and argued that it wasn't released. But this court said that it was foreclosed by agreement and therefore precluded under the relitigation exception. The primary argument that the Huey plaintiffs have as far as why they say that they're not in breach of their representations and warranties is they say that they're not seeking termination. There's a representation against seeking termination. And they say that they're alleging that the lease terminated automatically, so they're not seeking termination. But as I've mentioned before, I think the problem with this argument for them is it ignores that they entered into this settlement agreement that, like I said, attests to the validity of the lease as of 2008. And now they're coming back and saying that the lease was actually invalidated in 1987 or 2004, 2005, both periods which are before the time that the settlement agreement covers. I think they also ignore the fact that there's multiple representations and warranties here. Even if they could get around this representation against seeking termination with their automatic termination theory, it wouldn't help them with the primary representation and warranty that they held a valid lease as of the settlement date. That representation would be breached regardless of how they characterize the supposed termination of their lease. And when we raised this argument both before the district court and this court, their response was that they believed in their representations and warranties at the time, but they changed their mind based on a subsequent investigation in 2017. And that argument doesn't make sense to us because these are representations and warranties of fact and law. They're not representations of belief. So you can't get out of them just by saying you believed them at the time, but now you've changed your mind. And in fact, under West Virginia law, which is the governing law of the settlement agreement, you cannot walk away from settled issues based on a subsequent investigation. That's the Devane v. Kennedy case, and it incorporates the Davis case that we cite in our brief that talk about the importance of finality in respect to settlements. And they didn't say anything in response to that in their opposition. So we think, at least on the briefing, they've essentially conceded that issue. So just to sum up, the Huey plaintiffs are class members in breach of their representations and warranties. We think that triggers the exceptions to the Anti-Injunction Act, and that this court should reverse the district court's decision with an instruction that the Huey plaintiffs are class members and that the state court action should be enjoined. And we've cited authority for this in our brief, the Resit case, which vacated a district court's denial of a motion to enforce a settlement agreement with instructions to apply the correct law. And also the Montgomery Ward case, 92 F3rd 1180, reversed the district court and ordered it to enter an injunction under the exceptions to the Anti-Injunction Act where it failed to do so. So those were the primary points I wanted to cover. I'm happy to take any questions, but if there's no further questions, I'll sit down.
Thank you, Mr. Honey.
Thank you, Your Honor.
Mr. Russell.
Thank you, Your Honor. James Russell on behalf of Marcus Huey and 17 others that we're calling lovingly, in this case, the Huey plaintiffs. Your Honor, in 2017, our clients brought this claim in Wetzel County, West Virginia, and the argument has been kind of distorted a little bit in the briefing before this court. The argument on the trespass claim is that EQT failed to produce on a flat rate well. And by failing to produce on a flat rate well, which was later discovered by the plaintiffs, the habendum clause or the cessation clause was triggered. And this particular lease was then lost by EQT, and it was in 2013 and 2014 when they came on and drilled and committed the trespass. So we feel our trespass claim was timely in that regard. However, as far as the issue before this court, what we have said is that Judge Goodwin correctly analyzed the issue by looking at the fact that if the Huey plaintiffs knowingly made inaccurate representations or obtained some kind of settlement proceeds to which they were not entitled, the remedy was to seek repayment, not the extraordinary remedy of an injunction against this trespass claim, which he found centrally was not covered by the release and the settlement agreement and was not barred by his judgment order in 2010. And that's the central finding that Judge Goodwin made, which is being kind of ignored by EQT in its briefing before this court, because that answers both exceptions to the Anti-Injunction Act. It answers the issue of the in aid of jurisdiction exception, because as Judge Goodwin found, this is not a claim that is a royalty claim under the settlement agreement and is not a claim that was barred by his order on April 28, 2010. By making that finding, he is saying there is no threat to his jurisdiction here. And as far as the relitigation exception, of course, by making that finding, he's saying this is not an issue that was addressed, settled, or otherwise compromised in the K Company class action that was before him. So we believe they have essentially sidestepped this issue by ignoring his central finding in that regard. That finding is well reasoned, because as he explains, the royalty claim definition in the settlement agreement, which was incorporated into his orders, went to the issue of what payments were made on royalty, the proper payments of royalty, and included that phrase at the end of the paragraph in describing all the claims that were being released and forever barred. And this trespass claim has nothing to do with payments of royalty. I would differ with my opponent here as far as what is allowable under West Virginia law in a trespass claim, because, and I don't say this lightly, the judge in the case has already ruled on that issue. That was not before Judge Goodwin, unfortunately, but the judge in our case in Wetzel County has already ruled that these payment of flat rate royalty payments does not keep a lease going forever under West Virginia law, that the cessation clause still must be given effect and production still must be looked at. So to suggest that somehow that issue is alive and well for Judge Goodwin to look at, but ignore the fact that the state court in West Virginia has already decided that issue in this case. And so Judge Goodwin was correct in finding that this trespass claim was never contemplated, never looked at. And in fact, the class counsel made a similar argument when they briefed this issue before Judge Goodwin, that this was not something that was contemplated or could have been contemplated because it's individualized to whether or not production on that lease continued for the periods of time indicated. The part of Judge Goodwin's opinion that EQT is called nonsensical is essentially a discussion of the alternative arguments being leveled by EQT. And what Judge Goodwin said was that if the jury in Wetzel County determines that in 1987, the production was not sufficient to sustain this lease, then the issue could be brought up by EQT that the Huey plaintiffs should not have been members of the class. Now, that is something they could raise. They could raise in the federal court if they chose to. But then he also pointed out if it is 2004, 2005, that the jury determines that the production was not sufficient to sustain this lease, that is a more murky issue because, as EQT has said, there are representations and warrants within the class settlement process in this case. However, the representation and warrants do not say, and that's the issue that Judge Goodwin said was not squarely presented, those representations and warrants do not say that I am warranting that I have a valid lease on the date of settlement. They say I am warranting that I am an owner of a covered lease and entitled to payments. This time period that was covered by the lease, by the settlement, was 2001 to 2008. There are various points in that time period that some people would be entitled to payments. Some people would not be entitled to payments. Some people would be an owner for a period of time. Some people would not be an owner for a period of time. There is no warrant, however, in this settlement agreement that the person who has filled out the claim form is warranting that on 2008, when I sign this form, I am warranting that I have a valid lease on that date. And that's what they've represented to this court on the briefing. That's what Judge Goodwin was correct in saying was not squarely presented to him below. That argument is not consonant with the actual warrants and representations in the agreement itself. But his central finding is really the answer to both exceptions, and that he is finding that this is not a royalty claim. It's a common law trespass claim. Counsel today suggests that it was pled under the breach of duty of good faith and fair dealing or unconscionability. Therefore, it's somehow a contract claim and therefore a royalty claim.
What's the basis for your damages in the trespass claim?
The basis for damages would be the idea that the 2013-2014 drilling of our client's property would have been an unlawful taking of their property. So it would be the value of those resources taken in 2013, 14, and going forward.
Which would be sort of based on a metric of royalties, wouldn't it? Loss of royalties?
Actually, loss of value, Your Honor.
But how is that value calculated?
That value in
what royalties factor in that value?
Actually, it's valued on the basis of the price received for the gas and the market value of the gas. Under West Virginia law, if the trespass is intentional, the party who has trespassed owes the owner, the innocent owner, they owe them the full value of that without regard to their cost in drilling and producing the gas at the market value of the gas taken. If it's an innocent trespass or a non-intentional trespass, they can discount that value for the cost it took to drill and access the gas itself. But that's the basis for the damages. So the damages won't even start and don't start if our trespass is found to be true. Doesn't start until they actually entered in 2014 and started extracting gas.
So when the cessation clause was triggered, that happened. The trespass was after that.
Correct, Your Honor.
All right.
Yes.
And then you could have acted on that, right?
Correct.
As owner.
Yes, as the owner. Our trespass claim wouldn't even spring up until they actually entered and drilled in 2014. They produced in 2014. They started drilling in late 2013. Yes.
So the cessation alone does not trigger any rights to yours because
that is correct,
because of the flat rate nature of it.
Correct. Yes, the cessation clause only determines whether or not they're innocent, intentional, or otherwise. Right. Our ownership of those minerals has been, proven throughout. It depends upon our ownership of the mineral estate, not the actual cessation clause. I did want to address what Judge Floyd had asked about, which is this idea that somehow this trespass claim would fit under a royalty claim. They cite to our complaint in that case in which we plead it, and it's pled under a topical heading that is the unconscionability and good faith and fair dealing topical heading. But in West Virginia, we're a notice pleading state. It's not, we don't determine that something is standalone or not standalone, depending by, the labeling of a topical heading in the complaint. And our actual allegations are found on page 278 of the joint appendix, paragraph 91 of the complaint, as well as page 269 of the joint appendix, paragraphs 34 through 36. And if you look at those allegations, the allegation is not that there was some breach of good faith and fair dealing that triggered this trespass. It is that there's a failure to produce, and that there was a failure to produce, and that they failed to continue operations under the lease. And then in paragraph 91, what we actually plead is that it's a violation of West Virginia code and the common law of West Virginia on trespass. And so that, we believe, is defines this as a standalone, and the state court in West Virginia has made that finding that it is a standalone claim. So we believe that representation ignores the actual wording of our claim and the actual pleadings of in our case. So I did want to respond to that, but in essence, what we're saying is Judge Goodwin was correct in looking at the idea of, is this a claim that is covered by the settlement agreement? Is this a claim that is covered by his final judgment order, barring future claims? And answer that in the negative. And then he went into a discussion of, okay, these are the other arguments that EQT makes, which he found were not squarely presented, but he went into that discussion. And what is overarching in his opinion is the idea that he exercised his discretion appropriately. He looked at the idea of, what is my interpretation of the settlement agreement that I retain jurisdiction over, and my order that I retain jurisdiction over? He interpreted that. He interpreted it correctly, and we believe in that regard, he exercised his discretion appropriately under the standards set by this court.
As a follow-up to Chief Justice Grady's question about damages, I take it that under an intentional trespass, that the amount of damages would be much greater than any royalty claim.
It would, Your Honor, because in essence, even if somebody, well, in practical terms, when somebody comes in and drills and then starts paying a royalty, and this is rough, but you're talking about 1/8 and 7/8. You're talking about a portion of the value is supposed to be paid as a royalty to the owner, and a portion of the value is kept by the producer as their revenue and their profit margin. In a trespass, intentional trespass claim, what the court in West Virginia has said is we disgorge that. We don't let somebody profit from their intentional misconduct. So that 7/8 that they were keeping, that's all the owners. Every bit of the value belongs to the owner of that mineral because they weren't entitled to take it in the first place. If any questions, I don't want to repeat what's already fully briefed in the briefs to this court, but I'd be happy to answer any further questions.
All right. Thank you, Mr.
Thank you, Your
Honor. Mr. Russell, you have some time reserved.
Yes, I'd just like to address a few points, Your Honors. The first is that my opposing counsel said that the cessation clause must be given effect because the state court has decided that issue, but that we don't agree with that at all because the state court, to the extent it did decide that issue, ignored what this court said in Wellman, which is that when you have a flat rate lease, the fact that if there has been any cessation of production does not terminate the lease because the flat rate payments have been made. There's no dispute here that the flat rate payments have been made. That's enough to hold the lease. So that's one point, as we think the Wellman case is controlling there. The second point is as to the question of whether trespass is a royalty claim. Again, we think it is a royalty claim, but even if it's not, it's precluded by the representations and warranties, which are independent of the release of royalty claims. And if we go to JA 102, JA 102 is where we have all of the representations and warranties. The release of royalty claims is at the first full paragraph on JA 102. The representations and warrants are in the second full paragraph. These are independent provisions. They're not linked to each other. If you were to read the representations and warranties as being subsumed within the release of royalty claims, it would render that provision totally superfluous, that's not how we can interpret the contract. They have to be in there to do something. And the only way to give them meaning is the interpretation that we're arguing here. And on that point, actually in American Honda, the claim that was precluded there was not a released claim. That case had an underlying class action settlement of RICO claims against Honda. And then you had this collateral claim that one of the class members had against their lawyer for malpractice. And that ended up being precluded under the native jurisdiction exception because it interfered with the settlement by requiring an interpretation of the settlement. So that was not a released claim, but it still triggered the native jurisdiction exception. Here, we believe that the Huey plaintiff's state court trespass claim interferes with the settlement by breaching the representations and warranties. So applying American Honda, the exception should be triggered for the same reason. It's actually very similar to the Imprellis herbicide case that we cite in our brief, where there was a settlement of products liability claims, and then one of the class members brought a state court claim in West Virginia for fraud. And just as the Huey plaintiffs are doing here, they said that this is our independent fraud claim, and it's not released by the settlement. We should be allowed to proceed with it. And the court said, no, this claim, whether it's released or not, it implicates the settlement agreement. So it's precluded. And that same reasoning applies here. And staying on JA 102, I think it's also should be noted that if we go to the bottom of JA 102, the third full paragraph, the last sentence, there is a reservation of claims here. It says flat rate subclass members who join the class settlement retain their rights to bring an action for conversion of their lease in the future. So they did reserve some claims. They had the right to convert their flat rate lease into a volumetric 1/8 royalty lease. They did not retain the right to say that their lease was invalid at the time of the settlement. That's important because in Keith v. Eldridge, there was a very similar situation where this court said that you retained some rights to bring future claims. You didn't retain the right to bring the claim at issue. So that claim is precluded. My opposing counsel also said that there's no representation that the class members held a valid lease as of the settlement date. If we look at the representation at the second full paragraph, I'll just read it because it's short. As consideration for this settlement, the undersigned class member represents and warrants that he or she is the owner of the interest in the lease reflected in the claim form.
Yeah, that's a different thing. They want to warrant, they never say that they're warranting that the lease is valid. They're only warranting
valid lease. And this is reflected in JA 101 at the bottom where this is also, it said it warrants the subclass member's ownership period in the covered lease. I think if you're warranting that you have an ownership in a lease, it must be a valid lease. If the lease became invalid, you would no longer have ownership in that lease if it ceased to exist.
That's not what they're saying. They're just not warranting that it's valid. They may have a valid lease, but they're not warranting that. Isn't that what that means?
To me, if you're warranting that you hold an ownership interest in a lease, as part of that, you're warranting that you have a valid lease. Because I don't think you can have an ownership interest in something that's invalid. The last point I wanted to point out briefly, I see I'm just out of time here, but my opposing counsel said that there was a repayment provision that Judge Goodwin found. There is no repayment provision. There's an indemnification provision. That's in the second full paragraph on JA 102. That contemplates a situation where there's a dispute among adverse lessors over who's entitled to a settlement payment. But that's not the situation where a lessor comes in and says that their lease is invalid and they're not a class member to begin with. And I see I'm out of time. So unless there's further questions, I'll stop there.
Thank you, counsel. And matter of fact, thank you both for your arguments. We would love to come down and shake hands in our normal tradition, but under the circumstances, we cannot. But no, nonetheless, we appreciate your being here and your arguments. And we wish you well and be safe. And thank you so much.
Thank you, Your Honor.
I ask the clerk to call the next case.
Thank you, sir. May I begin?
You may.
Good morning. May it please the court. My name is Ben Glass. I'm here on behalf of Robin Thomas. When a claimant, Your Honor, in an ERISA-governed long-term disability insurance case has her claim denied, ERISA promises her ERISA promises her what they call a full and fair review. And there are two parts to a full and fair review. The first is a denial letter that fairly speaks of the reasons why we are denying your claim. And second, access to the pertinent documents that we, the insurance company, relied upon to deny your claim. I think the big issue in this case, Your Honor, is the refusal of Aetna to provide the claim file to my client when she asked for it. But I want to touch for a moment on the denial letter because I think it sets up this bigger problem. If you look at the initial denial letter in this case, it lists really one reason why we're denying your claim. You'll recall that this lady was on, you've been in a car accident, was on short-term disability benefits for about 4.5 months. Aetna was managing that. Gets near the end of that term, they terminate her short-term benefits, and because she had applied for long-term, they deny. They say your claim for long-term benefits is denied. And here's the reason. It really lists one reason. The reason is 2 conversations. So conversations that we, the insurance company, have had with 2 of your healthcare providers. A Mr. Almquist, he's referred to as a doctor in the denial letter. He's not, he's a physical therapist, and a Dr. Nguyen. So in that first denial letter, there's a mention of medical records, but there's no analysis. There's nothing that says, oh, we looked at all these tests, they're all negative. We don't think that you followed up with your treating doctors. There's none of that. And so, but when you look at the final denial letter, which is at the end of the period, there's about 10 brand new reasons, mainly based upon an analysis of the medical records that didn't appear in the first denial. So that's a fundamental violation of ERISA. Insurance companies, who's almost always an insurance company, can have an opportunity to participate in a meaningful dialogue. I sent you my records, you denied my claim. Why? Oh, well, let me go fill in the holes. Let me try to overcome the reasons. So as a first matter, that initial denial letter fails. And we know that it fails because there's 10 reasons in the second one, and there's 4 more reasons in the brief, and Aetna's brief in this court, which aren't even in either of the 2 denial letters. Now, you could almost forget, because in every case, a claimant asks for a claim file, and it's routine. The claim file is allowing a claimant to, as you know, she, the day after Aetna told her that they was initially denying her long-term disability claim, she says, I'd like to appeal that. Yesterday, this court issued, it's a published opinion in Shoup, which is a long-term disability case. And in Shoup, the court uses the phrase, what the claimant did is asking, he begins asking for the process of a full and fair review of the claim. And now this policy that said, we're not going to give it to you at all. And that claim file had information, a lot of information in it. It was rich with information that she could have used to provide herself new information for Aetna. Principally, you'll recall that her claim was she'd been T-boned in a car accident. She had 6 prior neck surgeries. She had a lot of head and neck pain, and she complained of cognitive dysfunction. So dizziness, forgetfulness, inability to string sentences together, things like that. It's not in the initial denial letter, but in the claim file, we see the report from one of the Aetna specialists, Dr. Siegel, one of the Aetna reviewers, who says, I see all these complaints. I see they're noted through the medical records, but they're only subjective. There's no objective evidence of them, like a neuropsychological evaluation. And a neuropsychological evaluation, as you probably know, is testing which, my words, makes objective things like an inability to word find, have short and long-term memory, think logically, things like that. Now, so it's clear that Aetna violated in two ways. One, the bad original denial letter, and two, in saying, no, that's our policy, you can't have the claim file. So the real question is, did that matter? Because if you go all the way back to, there's a case called Ellis versus Metropolitan Life. So there's two cases that I think are important for this case. And one is Gagliano from 2008, and the other is Ellis versus Metropolitan Life. There's a third case, it's this court's unpublished opinion 2 years ago, in a case called Odell, which also dealt with ERISA. And in Odell, there was an audit. It was a pension case. There was an audit the claimant was looking for. The administrator said, no, you can't have it. And this court asked, well, so what difference would it have made? And that's the question that gets asked here. Well, if she had had the claim file, what difference would it have made? Well, we know this. 1 year after her accident, after this claim is closed, she does get neuropsychological evaluation. And she does have testing. And that testing found profound disturbances in her cognitive ability. It found that she scored below 50% in a number of cognitive areas. So had they either said in the initial denial letter, look, there's no objective evidence of a cognitive disorder, or had they given my client the claim file that she can now look at and go, oh, this reviewer is looking at this and saying there's no neuropsych here, let me go get a neuropsych. There's very strong evidence, because we know what it was like 1 year post-accident, very strong evidence that it would have mattered. And you and I, this court in Ben Glass, shouldn't be here debating, well, the quality of evidence was one better than the other. That's what ERISA, in providing for meaningful dialogue at the claim level, that's where that discussion should take place. She was denied her full and fair review because the denial letter was bad. They didn't give her the claim file. Aetna doubled down in its brief, didn't say this is a mistake. This is Aetna policy that I'm here to correct. And what I'm asking the court to do is to remand the case to the district court, to Judge Hilton, with instruction to remand the case to Aetna and give her full and fair review. In other words, to restart her appeal process. And we will be able to now address all of the issues Aetna raises in their second denial letter and all the additional issues that they raise in their brief. There's this new information now, because she has this neuropsych, which was too late for the claim because she didn't know. And she's got a Social Security disability award. So Aetna should look at all of that information, and we should have the opportunity. What I'm asking for is the opportunity to be able to take this information back to Aetna and give her what ERISA guarantees her, which is the full and fair review. So,
I take it.
Yes, sir.
We don't allow fishing expeditions. There has to be a causal connection. And correct me if I'm wrong, there is a causal connection between the ultimate denial of the claim documents and its failure to provide the relevant documents as absent the information in the file. Whereas those things, what's in that file that you know now is related to their failure to give you those documents.
Well, there's a couple of things. So first, there's the 10 specific new reasons in the second denial letter that she's never been able to address. And for example, some of those are, we looked at the record and it appears that you did not accept a surgery, a trigeminal neuralgia surgery that one of your physicians was recommending. Now, I don't know if that's a good reason or a bad reason, but that's in the claim file, and she should be able to say, well, you know what, I've had 6 prior neck surgeries and Dr. Nguyen tells me there's other treatment available to me. So that's an example. But the biggest example I would point to, Judge Floyd, is the neuropsychological evaluation that was done February 1 year post-accident. because it strongly shows that she had significant cognitive dysfunction. And again, my argument is that if she had seen in the claim file that a key argument that the reviewer is using is the lack of a neuropsych evaluation, then she would have at least had the opportunity to go and get one. And I should be allowed, and she should be free to argue that it's likely that a neuropsych done earlier than 1 year post-accident also would have given objective evidence of significant cognitive dysfunction. Remember, she had a pretty high-end job working for Booz Allen. She worked with numbers and spreadsheets and met with teams and worked with a number of screens all the time. And from the beginning of the claim, her principal complaint was, I can't think straight. And her employer said, you can't come back to work until you are 100%. Because Edna had an argument that she could go back to work with some accommodations, which really involved, I think, like putting a neck brace on and looking at various screens. Anyway, does that answer your question? Because I think that is the most significant point I would make, the subsequent neuropsych, as to why it actually matters. And let me just say this for a moment, Judge Floyd, because the rule shouldn't be that an insurance company is allowed to have policy that says we can say no, because I tell you that will encourage this sort of activity.
Let Gagliano answer that question.
Well, I think it does. I think Gagliano, Ellis, and you won't find a case in the country that says you're allowed to have that policy and that you're allowed to just say no. So I think the question has already been answered. I don't understand. Ben Glass doesn't understand why Aetna doubles down on this argument and didn't just give her another review. But the question is, would it have mattered? And I'll say this finally, and then I'll sit down, is the bar for Robin Thomas should not be high to show, because what are we aiming for? We're aiming for an opportunity for a meaningful review, for a meaningful dialogue, is what the cases, including this court, have said, a discussion, so that we make these claims efficient. These people don't have to go get lawyers. Don't drive up the time and the expense of getting a claim resolved. That's the balance. ERISA gives these insurance companies discretionary standard of review, and that tilts the playing field. But ERISA then takes its regulations to try to balance that tilting of the playing field as best it can by saying, here's the file. And it's the only type of litigation, I do a lot of tort litigation, the only type of litigation where you get the entire insurance company claim file, and they have to give it to you, and they have to give it to you for free as soon as you ask for it. And I'll tell you that routinely, client comes in, have a denied claim, we send the letter, in 30 days, we have a claim file. So anyway, I'll sit down unless the court has any other questions about this.
All right.
Thank you.
Thank you, Mr. Glass. Mr. Downey?
So, good morning, Your Honors. Brian Downey and Troutman, Pepper, Hamilton, Sanders on behalf of Aetna Life Insurance Company. The primary issue before this court is really whether Aetna abused its discretion when it determined that Robin Thomas was not entitled to long-term disability benefits, that she had not established her entitlement to those benefits. And as Judge Hilton appropriately found, that decision was correct. It was neither arbitrary nor capricious. Instead, it was the result of a principled and reasoned analysis. And Aetna determined that she was not disabled from that she had been disabled initially, because there is no question at all.
Mr. Downey,
Sure.
Obviously you can argue the case where you want, but oral argument is for maybe to answer our question, at least right now, mine. But you said it's not really a question right now, is it, whether Aetna was correct and had a sound reason for denying it? Isn't the threshold question is whether or not Ms. Thomas had an opportunity to have a fair and meaningful opportunity to address those issues before you made that final decision. So can you address that? See me, that's the core of the case right now. Can you address that, please?
Absolutely, Your Honor. And the answer is she did. So there's here's the issue that I think gets obscured through this discussion, which is there's a lot of talk about the lack of the fact that she didn't have a neuropsychological evaluation, and why is that significant? The underlying question behind that, though, is why didn't she have a neuropsychological evaluation? The answer is obvious, because her treating neurologist did not think she needed it. And the reason her treating neurologist did not think she needed one is if you look at Dr. Crutchfield's records over and over and over, what Mr. Glass said, that she says, I suffer from certain things. I suffer from cognitive impairment. I suffer from impaired memory. I suffer from an inability to speak. He examines her, and his answer is, no, she doesn't. She has good short-term memory, good long-term memory, is fluent in speech patterns, has a good fund of knowledge, and has no cognitive limitation that he identifies. And when he identifies the limitations, which she would certainly have some accommodations that would need to be made for her, or would have been made for her, when he identified those accommodations, they were all physical. He did not identify any neurocognitive limitation. So the record before Aetna is that according to her own physicians, she doesn't need that. The reviewer mentions in passing that she hasn't had that, which is true, as you would always look at in any case where someone is asserting a disability, when her physicians are saying that her condition is much better than she is. And so you see it in a mental health cases all the time, where
you're still not addressing my question, because you're going into the merits of your decision, which is fair enough when you get to that aspect of it. But right now, the question is whether or not she had a fair opportunity to address for your sake of argument, very sound reasons.
So fair enough. Sorry, and Your Honor, I started down that road and I sidetracked myself. I apologize. Let me get back onto it. The answer is yes. So the July 31, 2017, that is the initial denial letter. And what it does is as required by the then applicable 2002 regulations. It provides the specific reasons for the adverse determination and references her to the pertinent plan provisions. So it summarizes the applicable policy provisions, which is what is required to do. It explains the process of record review. It explains that there was an independent clinical review. So prior to appealing and prior to making the decision not to request a claim file before starting her appeal, she knew this existed. The idea that she was surprised or didn't know anything about it is just not true. And then, of course, it goes through the communications with the providers. So it has identified that she is not disabled, that the medical evidence does not support that she's disabled. It then tells her she has 180 days to submit an appeal. Of course, she's not required to appeal. Number one, that's her choice. But if she wants to, she has 180 days to do that. And they identified some areas of information that she could submit. She could get a copy of the record if she wanted them. And she's not required to do any of it. What she opted to do was to appeal immediately.
Was she informed that if she opted to appeal, that right to get her file would be cut off?
No, Your Honor. And if you think about what Ellis provides as law, what's the point under the Ellis jurisprudence about this? The point of giving her the claim file is so that she can prepare the appeal. She's already done that. Now, Mr. Glass might regret how she did it. She might regret how she did it, but she did it. And it's not the role of a claim administrator to step in either and interfere with her decision and say, no, you shouldn't appeal. You should do something differently. Or, as is even suggested here, interfere with her treatment to step in and say, you should be looking and you should be trying to get a doctor to get you this kind of testing, even though your treating physician doesn't think you need it.
Well, I'm just having a little bit of a problem. It's simpler than you say. She was told that Aetna does not release claim information, quote, once a review is in process. That is contrary to Gagliano and to ERISA, that they're entitled to that material. So why wasn't she entitled to? Why was she told no? Because there's an appeal in process.
So that they could process the appeal. I mean, it is so that it's they have the record. They're most of the way through it actually initially, other than they ended up now needing an additional review at the end. But that's the reason, Your Honor. It's do I wish they hadn't done it? I don't think they were legally required to do it, but I wish they had, because we wouldn't be here today on this issue at least. She had it. I'm sorry, Your Honor.
Is that issue the heart of the appeal?
Well, I understand that's what the appellant is trying to make it. I don't think it really should be, but because I don't think it's the issue that the appellant is that it has the legs the appellant does, but thinks it has. But if you're telling me it's the heart of the appeal, then I think I would defer to you on that. But it is a and of course, so what happens? Why does she ask for the claim file? She asks for it because she learns that there is a record, that there's a report that has been generated on appeal that that she wants. That's the trigger. And under the then applicable regulations, she was not entitled to get that. Now, the answer, if that happened today, the regulations have changed. So if she called today and said, I even want the IMR report, she would get it, or she wouldn't even have to call. It would have automatically been sent to her. But that just was not true at that time. And so when she got, what Ellis talks about is, why do you get the appeal? You get the appeal so that why do you get the record? You get the record so you can prepare the appeal. She did that. She could have done any number of things. She could have waited to appeal. She talked about how she had a lawyer. She could have had her lawyer appeal. But she opted not to do any of those things. And I think we're on dangerous ground when we start to say that a claim administrator is now somehow supposed to manage that, as opposed to do what it's supposed to do, which is once she files that appeal, the regs are, the clock is running.
How do you equate responding by giving her the documents to managing? I mean, in other words, one is, the first is, the form is to give the documents. The latter would be actually to do something to manage. Like, for example, sir, you're not going to say, well, listen here, I see the holes here, and therefore you need to shore up this, shore up that. That would be managing. But to simply give those documents a claim file, that wouldn't be management on Aetna's part, would it?
Not if she had asked at the beginning. Of course not, Your Honor. They should have given it to her. They would have had she asked for it. She didn't. She opted not to do that. So the management piece that now is being imposed is this argument that Aetna, instead of going through the normal appeal process, perhaps should have said to her, well, why don't you wait 180 days? Why don't you get a lawyer? Why don't you review the whole record? Why don't you ask us for things that you don't have? It's not the claim administrator's responsibility to do that. It's her right to ask for it prior to the appeal. She didn't, her right to hold the appeal, her right to get all those things. And Aetna said, once we were in process, because we're working with this right now, we're in the middle of this, trying to administer your claim under specific ERISA guidelines that we have to comply with. We don't send out a copy. We'll send it to you at the end, and that's what you got. You got one later. And the idea that it mattered, of course, we do know that after the denial, even though her doctor had not seen the need for a neuropsychological evaluation after the denial, she eventually got one. She got something, which is turned out not even to be reliable, which again is not surprising. I mean, it happens. But so that it would not have made any difference in the end. Now I can talk about the case itself, but my sense is that it might be better if you had specific questions about the, when I say the case itself, meaning the claim itself as opposed to the regulatory issue. If there, and I'm happy to do that, but I'm also, if there are questions about that, I'm happy to do that and answer them. Or if you feel you don't need anything further on the merits of the decision itself, I'm happy to stop.
Thank you so much,
Thank
Mr.
you.
Downey. Mr. Glass, you have some time reserved.
Briefly, and thank you very much. So we're not asking anyone to manage a claim. We're asking them to hit the print and send button. My friend on the other side raises the question, well, how come none of her doctors ordered a neuropsych before this? That's a question that needs to be raised during the administrative process so it can be answered. I have an answer for that. Happy to share it with you, but the point is that's an answer that's a question that needs to be tussled with during the appeal process. And the appeal process, it's important to remember, and I think that we all here do, is that it's not like an appeal to this court where you've got a closed record and you file your notice of appeal and now we're working. In these ERISA cases, an appeal sets off an iterative process. Just like in the case from yesterday, Shoup, a lot of things happen. Insurance companies get IMEs, Shoup got a FCE, and sometimes insurance companies say during the appeal process, we want to send you to our doctor to go get a neuropsychological evaluation. So that's all part of the process. My friend says, well, the neuropsych that she gets a year later isn't valid. Well, I think that's medical nonsense. And I should have an opportunity to address what I view is, and my experts would say is medical nonsense, that neuropsych is somehow not valid. And she didn't have a lawyer. I mean, look, she didn't have a lawyer when she gets the letter and she calls her claim rep and says, I want to appeal. And as a layperson, again, these regulations are written to protect people so they don't have to go get lawyers to have benefits of sometimes between $1,500 and $4,500 a month. And so we're not spending years and years doing this. It's meant to balance the playing field. So again, unless the court has any questions, I think this is a remand to Judge Hilton, again, with instructions to remand the case to the claim administrator. And either at the end of the Shoup opinion, the court mentions attorney fees and says in that case, that question should go back to the district court for the first time. And I know this court has done it in different ways. So just, if I win, I'd like to apply for attorney fees and just leave it to this court to tell me whether to make application here or in the district court when it goes back to Judge Hilton. Unless the court has any other questions, I'm good.
Thank you, Mr.
Thank you.
Glass, Mr. Downey, for your arguments. Again, as I said before, that we wish we could come down and greet you in our normal fashion, but we cannot under the circumstances. But please know, nonetheless, we appreciate your being here. And thank you so much for your arguments. Be safe and stay well. Thank you.
Thank you very much.
Clerk to police the
May it please the court, Howard Rubin presenting argument today on behalf of my client, Greg Lindbergh, and Mr. Brown's client, John Gray. I'd like to start with the erroneous jury instruction on the honest services fraud count. Your honors, there's no way around it. The district court directed a verdict on the official act element by deciding that reassignment is not an official act. In fact, the government begged the court not to do it. And yet, at pages 1880 and 81 of the joint appendix, the judge gave the erroneous jury instruction. He laid out on 1880 the elements of an official act from the Supreme Court's unanimous decision in McDonald. But in the next sentence, he says, quote, in this case, the charge is that the question or matter is the removal and replacement of the senior deputy commissioner and, quote, you're hereby instructed that the removal or replacement of a senior deputy commissioner by the commissioner would constitute an official act. The judge applied the law to the historic facts and told the jury the outcome. And that is inconsistent with Gaudin from the Supreme Court. It violates Fifth and Sixth Amendment rights. And in fact, you can actually look at the McDonald decision itself on this exact statute, because the court said there that the jury must find the elements of honest services fraud. But it was not the instruction in isolation. The court forbade the defense from arguing the official act element to the jury, forbade the defense from presenting evidence that reassignment was not an official act. That is quintessential serious prejudice. And that directed verdict has broad implications beyond this case, including for street crimes as well, if the judge is to take elements out of the hand of the jury and say that those elements have been met. Your honors, the court denied our motion for new trial and judgment of acquittal and said on this issue, the official act, the removal constitutes an official act as a matter of law and was obliged to instruct the jury the same. That's reversible error. But that error also infected count 2, which is the 666 federal funds bribery statute. Even before we get to the issue of whether there's an official act element, that instructional error on count 1 infected count 2 in the following way. It was the top of page 1881 where the judge directed the verdict with regard to honest services fraud and said, in this case, you're hereby instructed it's an official act. The very next paragraph, the judge says, he discusses the elements of bribery for this case. And of course, 666, the other count, is a bribery statute. And he uses the term official act twice. Then in the next count, he's charging on both counts 1 and 2, not just count 1. He's charging on counts 1 and 2 and says that the quid pro quo was campaign contributions in exchange for removal and replacement. But just on the top of that page, he had said, you're hereby instructed that removal and replacement constitutes an official act. He does it again on pages 1882 and 87. On 1882, he talks to the jury about what constitutes a federal crime in the case and says that the government must prove campaign contributions were offered in exchange for, quote, a specific official act by the commissioner. And then finally, on 1887, he is only charging on count 2 there, and he uses official act as part of that charge. He says, quote, it is not a defense to the crime of bribery that the offer or promise of anything of value was made to the public official to constitute, quote, an official act. Your honors, the judge took the quo in this case out of the hands of the jury on both counts 1 and count 2. So if you are to conclude that there was reversible error on count 1 because the judge, rather than the jury, decided the official act element, and you look at pages 1881, 82, and 87, you will find that that official act direction ended up infecting count 2. Your honors, my second point regards count 2 itself, the federal funds bribery statute 666, and our argument that it was reversible error for the district court not to include that limiting instruction to preserve the constitutionality of the statute. Your honors, a unanimous court in McDonald said that to save the honest services fraud statute and 201, the general federal bribery statute, and the Hobbs Act for that matter, a limiting instruction had to be used. McDonald would be a dead letter if this court does not apply the same limiting instruction to 666. When you read the McDonald decision, the Supreme Court that vacated Governor McDonald's conviction under honest services fraud would not have affirmed his conviction had he been charged under 666. The same constitutional infirmities apply to this other bribery statute. Now, in its brief, the government argues that 666 is a more expansive statute than McDonald. Yet somehow, for the government, 666 doesn't raise any of the same constitutional concerns, but logically, the opposite should be true. If it's a more expansive statute, and a unanimous Supreme Court said that we have constitutional concerns with honest services fraud unless we read an official act into it, then we would have the same constitutional concerns here. The McDonald court stated when it looked at federal bribery statutes, 201 and honest services fraud, and this is the words of the court, a statute in this field that can be linguistically interpreted as a meat axe or a scalpel has to be interpreted as a scalpel. Your Honor, 666 is in the same field. It's a bribery statute. In fact, this court in Jennings stated, recognized correctly, that 666 was a supplement to 201, which has the words official act into it. It's closely related. With respect to the constitutional concerns, the government's interpretation and what the district court did below does not comport with due process. The government's legal interpretation isn't just confined to this case involving campaign contributions for large sums. And the McDonald court itself acknowledged that we have to look at these bribery statutes and consider them not just for the cases involving large dollars. Take, for example, a situation where a state constituent goes to a fundraiser for a state official and says, I'll write you a campaign contribution for $5,000 right now if you reassign a subordinate in the licensing office who is not processing licenses for my business. She's lazy. She stops answering the phone after 2 p.m., even though the office is open till 5 p.m. It's really hurting me. You need to make that change. Well, that $5,000 contribution is legal in 4 of the 5 states in the Fourth Circuit that allow contributions of at least $5,000 for campaigns. And yet under the government's theory, asking for that reassignment, if it were to be done, that's an action being taken by an official in the scope of the official's authority. That can't be squared with McDonald. It lands us in the vagueness shoal that a unanimous court said was unacceptable, requiring a limiting instruction. Moreover, the court said you can't rely on prosecutorial discretion. When we're talking about vagueness concerns, and we are here on a First Amendment case because campaign contributions were the quid, you can't leave it to the prosecutors to determine what is an appropriate time and what's an inappropriate time to use this statute. Your Honors, I would argue that the limiting instruction here that we're requesting on 666 is more necessary than in the McDonald case.
Let me ask you this. There's currently pending before the Supreme Court, United States versus Roberson, where there was a court declined to read 201 official act requirement into section 666. We obviously don't know what the answer to that question is going to be, but it has direct impact on this case. As to your case, if we decide this case now before Roberson comes out, then I take it you want the official act language to be transferred to 666?
We think it's required as a limiting instruction consistent with McDonald and this court's decision in Jennings, yes.
Or my second question is, then you would be satisfied that if the McDonald limiting instruction was given in the 666 case, we don't need to talk about official act.
If the McDonald limiting instruction is given in 666, it would mean that official act is an element of 666, and the district court would have been required to instruct the jury on the 3-part test from McDonald And the jury would need to find, not the court, that those elements were satisfied.
Where in the text of 666 is that official act language?
It is not in the text, nor is it in the text of the Honest Services Fraud Statute or the Hobbs Act, two statutes where the Supreme Court unanimously said in McDonnell, you have to add that language in to preserve the constitutionality. I want to answer your question. I believe you were talking about Roberson.
Yeah.
And it is pending on a cert petition. Certiorari has not been granted. It is great to look at Roberson in contrast with this case. Roberson is an instance out of the 11th Circuit where it was a cash bribe for introducing and voting on legislation. That is an absolute core official act. And so while we disagree with the 11th Circuit, that where they said an official act element doesn't have to be grafted on, it's important to note the 11th Circuit said, quote, the official act in that case, quote, is undeniably an official act. And let me just clarify. They said that the introduction and voting of legislation is, quote, undeniably an official act. So while they didn't end up applying official act as a limiting instruction, it was tantamount to that. Your Honors, I will point out, this is the first case since McDonnell in a 666 case where a defendant who gave a campaign contribution has asked for the official act limiting instruction from McDonnell. I know that the government cites other cases like Roberson, like Eng from the Second Circuit. Those cases did not involve campaign contributions. They involved awarding of contracts or introducing legislation, or in the Eighth Circuit, there was a case where it was a bribe for increasing Medicaid reimbursement. And in Eng in the Second Circuit, that didn't even involve a government official. That involved a UN official. So the concerns about federalism and representative government were not formally in front of the court. Your Honors, a quick point with respect to federalism. The government's interpretation turns federalism on its head, because what it would mean is we have a more exacting standard with respect to 201 bribery, federal bribery regarding federal officials. It would be more exacting than a federal criminal statute 666 applicable to state officials. But the McDonnell court said in the unanimous opinion that we are not in the business of setting standards of good government for state officials. We are not asking this court to bless the conduct by the defendants, nor was the McDonnell court blessing conduct. They called that conduct distasteful, but they said their concern was ensuring that the statute could be applied constitutionally. Your Honors, my third and final point respects sufficiency of the evidence. If official act, Your Honors, can I clarify, is this my rebuttal time or my 16 minutes?
No, this is just 16 minutes.
Thank you. On sufficiency of the evidence, there is no dispute that the quo in this case is just the reassignment. That's what was charged in the indictment. It's how the jury was instructed, and it's how on page 1 of their brief, the government framed the issue for this court. There are two reasons why not merely you need to vacate and remand so that the jury can decide these elements on both of the counts, but why a reversal is actually required here. Because the reassignment without seeking an outcome on a specific matter is not an official act under McDonnell. Two of the elements to focus on. First, reassigning oversight is not a matter similar in nature to a lawsuit, an agency determination, or a committee hearing required in McDonnell. It has to be of the same stripe, to use their words, as one of those. This isn't an instance where the government was adjudicating, legislating, executing. Second, and I think even more importantly, the reassignment wasn't a decision or an action on a specific and focused matter relating to Mr. Lindsberg's business. Not only McDonnell, but Sun Diamond made clear that it's not enough that the action that the government official takes is related to a question or matter. Something more is required, to use their words, and you have to take an action on that question or matter. The government redefines the official act test on pages 37 and 45 of their brief, and their analysis of it and the elements are tantamount to simply saying that any act by an official in their official capacity satisfies the test. That's not right. And if you look at the evidence, Ms. Walker is the person that the two defendants wanted in the position of oversight. She testified that there was no ask for her to reach any outcome on any matter. She testified she didn't know the defendants. She never met Mr. Lindbergh. She might have met Mr. Gray once at an unrelated meeting. She never emailed with them, texted with them, spoke with them. When asked if there was a side deal with her, she says, quote, absolutely not, at page 1404 of the joint appendix. There's no evidence that the government presented that the commissioner pressured her or gave her advice on how to reach out and make a decision on any outcome. And I pick those words, pressure or advice, because the McDonald court says referring a constituent to another official is not enough. And here, the government doesn't have any outcome. They speak in terms of the affiliated investment threshold. Commissioner Causey testified that that had been resolved in a memorandum of understanding and there was no campaign contributions in exchange. And at the very least, this is a jury question that has to decide the official act element on both counts. I'll reserve the rest of my time if there are no questions.
Thank you, Mr. Rubin.
Thank you.
All right. Ms. Ray.
May it please the court. Excuse me, Amy Ray for the United States. Your Honors, the district court properly instructed the jury, and even on both elements, both on both counts, bribery in terms of honest services, fraud, and also in terms of bribery. But in addition to that, the evidence is very clear that the transfer of, or I should say the law is very clear, that the transfer of regulatory authority from one regulator to another constitutes an official act. So under any assessment of whether or not the district court properly instructed the jury, any error would be harmless. Now, turning first to the sufficiency of the evidence, there was more than enough evidence that the defendant in this case, the quid pro quo was not asking Debbie Walker to take a particular step during the regulation. It was to get Commissioner Causey to change the regulator. And just as the Second Circuit recently held in Reichberg, moving a government employee, promoting them, shifting them, that is an official act. That's a quintessential official act. So it is within the province of the decision maker, Commissioner Causey. It relates to a government function, and it's a discrete act, one that we can tell whether it happened or not. So discrete that Mr. Lindbergh pressed Causey over and over again. When's it going to get done? When's it going to get done? What he wanted done was to have a different regulator over his companies. That constitutes an official act.
So you don't think the jury should have any role in deciding that fact?
I'm sorry.
You don't think the jury should have a role in deciding that fact?
The jury does have a role.
Well, the judge took it away from him in the first aspect, and the honest services didn't. Said you directed to say this is an official act, did it not?
The judge did tell the jury that the removal of a senior deputy commissioner by the commissioner was an official act. Absolutely.
And the government at the time disagreed with that instruction.
We did, and on appeal, the assessment was: is this defensible? Is this defensible, or should we simply concede error?
I'm not taking issue with you're being here now arguing something different. I understand that, but I'm just saying that the present sense, as a very esteemed and experienced lawyer, that it was wrong.
We asked the court not to do that because we knew that we had ample facts to support the jury's. We felt very confident that the jury would find an official act. We didn't need the judge to go that far.
Right.
So we asked the judge not to.
So we have to look at that, in my view, in the context of what that told the jury. And as Mr. Rubin argues, and when it goes to the second count, so the question whether or not official act is even required, but assuming that it is or isn't, either way, that they bled together with it and said, well, the only official act that you alleged in this case was, as you said, transferring or moving authority of one person to another. So if that was directed to be an official act or wrong, not official act required in the second, but a wrong, wouldn't that be conclusive to the jury on that part?
I would say this, Your Honor, if this court were to hold that it takes away the province of the jury to find official act, okay, that's one element out of 7 that the jury was instructed it had to find in order to find the defendant guilty of honest services fraud. So that would be amenable to harmless error review. It's not a situation where the court directed the verdict on all of the elements.
Why is this element structural, and therefore harmless error wouldn't protect you?
Sure, Your Honor. Judge Floyd, it's not structural because as this court held in Laverne, that if the district court errs in instructing the jury on one element, not all of them, that is not structural error. And the Supreme Court's recent decision in Greer makes that very clear. The Supreme Court's decision says structural error is something that affects the prosecution sort of from start to end. The jury wasn't given the appropriate reasonable doubt standard, so it couldn't find the judgment on all the elements. There was no lawyer for the jury, for the defendant. It's an error that infects the entire proceedings. Misinstructing the jury on one element is the same as not instructing the jury on an element. Supreme Court held in Nader that is not structural error. That is amenable to a harmless error review. There's no difference between telling the jury that they have to find an element than in not instructing the jury and requiring it. Either way, the jury has not found that element. So Nader governs, Greer governs, Laverne governs, and the only time this court has held that there was structural error that I'm aware of in a similar context was in Ramirez-Castillo when Judge Thacker authored the opinion and held that where the jury was never asked to find guilt on any of the elements, it wasn't asked to reach the legal conclusion, that's structural error because that's directing the verdict on all of the elements. Here, the jury still had to find that there was a conspiracy. Yes, Judge Traxler.
As your opponent pointed out, regardless of how you view the standard of review for what the judge did charging the jury, there's more than that in this case in that the judge prohibited the defendant from introducing any evidence about it either. So how would you put those two problems together and tell me again why we would apply harmless error to the situation?
Sure, absolutely, Judge Traxler. So the judge did not prevent the defendants from presenting evidence. If you look at page 1564 of the appendix, the judge actually allowed them to make an offer of proof on this issue and even said after they did that, they had a gentleman called Mr. Louis Balo testify, basically testified that, look, you can move employees with an email, you can do it with a conversation, that reassigning a file is not something that requires a lot of formality, right? So Mr. Balo testified them to argue that it was not because if there was no, of official act was overwhelming, and it was, then it would not matter if the judge had allowed them to argue. It doesn't affect their case because they simply weren't allowed, even if they were excluded, they weren't allowed to put evidence on a point that essentially is uncontroverted, the evidence credibility. They challenged, they had a big press on entrapment. Yes, Your Honor.
So is your argument that if the evidence is overwhelming, the jury doesn't need to decide that element?
My argument, Your Honor, is that where a judge takes that from the jury, the Supreme Court has made clear that it is amenable to harmless error. So this court then has to ask, can we say, based on the evidence presented?
I'm presuming you're relying on Nader for that statement, but Nader's a completely different situation where there was no instruction at all. This is a situation where the judge will not let them consider it. He tells them what's the factual finding for them.
Takes that question from the jury, right? If it's not offered,
okay, go ahead.
If it's not asked.
Okay, Bill or Sally, when you take over for Jane while she's gone, so you're saying, oh, that's an official act because another person is performing the duty. A jury may have a different view of that. I may have a different view of it, but that's why people ask for jurors and not the judge. And the judge, instead, not being critical, but it's just the fact of it. Said, listen, when it comes to this, this is clear. This is an official act, and you can't argue anything. Now, as to the proffer, that's even worse. You said, okay, you can argue those things. You can put that in about those things. It could be done by an email and that, but you can't tell the jury that this, what they did, does not constitute. Then that's the whole point of summary and summation. Any lawyer will know, and you know that. Talking to the jury to be persuasive, they're telling you can't be persuasive because I'm not going to allow you to be persuasive on this because I've told them what it is. And this issue, why you keep saying that it's one, this is a sine qua non of this case. It's all about whether you wanted to remove this person. So it's hard to say this is the 800-pound primate in the room. You may have 6 others, but for this case, this is the sine qua non of this case. That is whether or not removing this person for money constituted both the honest services aspect and the bribery. So,
Your Honor, with all due respect, we did have to show that these defendants wanted to remove this senior deputy, Ms. Abusek, right?
Right.
Yes, that was the issue.
Really?
Did it happen?
Not where this statute is. Since that's the issue of this statute really is for jurisdictional point of 666, and the honest services is whether or not you have the tentacles that connect the official act or this thing. I mean, it was pretty clear that they wanted it. I mean, that was the easy part. The tough part is, does it make any difference removing a person from a job when that's a personnel matter? Is that official act? And you say it's clear, but I'm not sure that's a clear question. In the McDonald case, it wasn't clear whether or not you could do these things that he was alleged to have done. Supreme Court made it clear, no, it has to be tied because otherwise it's too broad and it's vague. And I still think there's a question. I know you're counsel for the government. I appreciate that. But I don't think it's absolutely clear that removing somebody from a personnel position is official act. And you do, but I'm not sure it's clear.
So I would suggest, there was a lot in that.
I know, I'm just going.
I'm started thinking about which part I want to respond to.
Go ahead.
I want to make clear that one of the important issues and one of the things the jury actually had to find, in fact, I would say it was the most important, was whether or not Lindbergh and Gray offered money in exchange to have Mr. Causey remove Ms. Abusek, regardless of whether it was an official act. The real question was, did he do it? Did they do it? Did they intend that? Was the intent there? Was there an intent to defraud, et cetera? And they defended vigorously on that question. Now, in terms of 666, and let me just, one other point on that, on the honest services. I would note that numerous courts have held that various conduct constitutes, as a matter of law, official acts, right? And that includes the Supreme Court, which says, yeah, if you actually had to choose whether or not to do a research study, that's an official act. And the Second Circuit says promoting or reassigning an employee is an official act. They say that as a matter of law. Numerous circuits have held that. So I don't think this court is going out on a limb in saying that we proved, based on the evidence about how important Abusek was, they were willing to pay $2 million to move her. That shows that they believed that movement was going to be important to their companies because it was about the dollar. Now, turning to 666, because I only have a few minutes left, the question is, do the text, the purpose, the structure, and the history of 666 suggest that official act is required? Now, one thing to know about McDonald, and remember about McDonald, the parties in McDonald agreed that the official act was that they were bound by official act as defined in 201. The Supreme Court did not hold that. The parties agreed that they could only be convicted, and the government and the defendants, if the government proved an official act for purposes of honor services wire fraud. All right. That is not an issue in 666 because 666 is a different statute. It's more specific in some ways. It tells us what the defendant has to have bought, and what the defendant has to have bought is an action by an official. It does not say official act. It doesn't need to. There's nothing in the language that says that. And the Supreme Court did not hold in McDonald that honest services fraud requires an official act because the parties agreed to that fact. Here's why vagueness is not a problem in 666. Vagueness is not a problem because 666 is more specific. It says if you pay money and you do it, and by the way, there are federal funds on the table, right? 666 has the requirement that state or local government or whatever agency it is has to receive at least $10,000 from the federal government. And the bribe has to involve at least $5,000. So right there, we have limitations that do not exist in honest services wire fraud. And it is also, so it's a broader statute in
Bribe
terms
them
of
to do what, though?
any act by an official, but let's remember there is an intent requirement. The defendants suggest this parade of horribles that if I go and give my, congressman $500 and then I thank him for not hiring, for firing a racist regulator, that somehow I've gotten myself into trouble under 666. That's not true. We have to show that there is an intent when I give that $500 that I say and I intend, I'm only giving it to you if you do this or because you did that, right? So there is a requirement. There has to be, the bribe has to be tied to an action. But 6 circuit courts of appeals have held after McDonald that 666 does not require an official act. Every one of them has been asked, please tell us that you're going to apply McDonald to 666. All 6 circuits have said no. So this circuit would be going out on its own, which I admire courage.
That's a bigger problem. Even if it's not required to have an official act on the 666, the judge told them that that act, the only act that you're furthering in the prosecution, is the type act that accomplishes that.
It couldn't matter under 666 because as long as it was an official, and they don't dispute that Commissioner Causey was an official, they don't dispute that, as long as they were paying him to do an act.
Any act.
Any act within the scope of his, it doesn't have to be an official act.
Oh my goodness, you really gone way beyond McDonald now.
If they are,
any act. Go ahead.
Your Honor, if they are paying him as an official to do an act within the scope of his authority, that is all 666 requires, and 6 circuit courts of appeals have so held. And even though Mr. Rubin suggests, that really doesn't, they really didn't hold that because in none of those cases was official act really an issue.
For example, if they said, Governor, I went by the mansion and I looked at your shrubberies. I would really give you some money if you would just fire your garden and get a different one. That would be official act because he has the authority to change gardeners, right?
It's some conduct. It is some conduct that if you pay an official and you get money from the federal government and you pay an official money to do any particular act, that is cognizable under 666.
Right. Okay.
And that is what every court who has looked at it has held, Judge Gregory. I'm not going out on a limb here. This is what every circuit court has held. That McDonald
circuits may have, but the Supreme Court of McDonald's certainly suggested that's the limb that's too far.
Your Honor,
in terms of vagueness and saving the constitutionality of the statute. But go ahead. You understand your argument. Go ahead.
I want to respond to that. McDonald did not say that. It said it as, and I see my time is up.
You can go ahead.
McDonald said that as to Section 201, which is a different statute, which both parties agreed applied in McDonald. That's critical. No party has agreed that 201 applies in 666, and it wouldn't and it couldn't because 666 was designed to expand upon 201. It came after, and it was designed to broaden the basis of liability where there were federal dollars on the table. So it is not required. Even if it is required, I would suggest that we presented more than enough evidence for this court to be able to say beyond a reasonable doubt that the conduct of moving one regulator and getting rid of one regulator in favor of another, for which Mr. Lindbergh was willing to pay millions of dollars, constitutes an official act. Thank you. We respectfully request that the court affirm the judgment of the district court.
Thank you, Ms. Brain. Mr. Rubin, you have some time reserved.
Thank you, Your Honor. A few points. I'll start with the government's argument that this isn't harmless error, but I'll be brief. This is not either Nitter or Greer. Both of those were instances where there was an omission of an element. Here, the judge directed the element. Here, it was highly contested. This is not Laverne. Laverne applied harmless error analysis where neither party disputed its application and there was no briefing on the harmless error standard. Rose v. Clark was affirmed in Netter in a footnote. Netter says, we are not doing anything to disturb our decision in Rose v. Clark that says directing a verdict against the defendant is unconstitutional. Ms. Ray mentions the Bellow testimony on 1563 of the joint appendix. The judge says, yes, that evidence can come in about the informality, but here's the quote. Most of this evidence can come into evidence in front of the jury as part of something if you're trying, as part of your defense, if you're talking about your entrapment defense or any other part of your defense. And on the next page, he says, if anybody tries to argue on official act, I'm not going to let you do it, and I'm going to tell the jury it is an official act. That's at 1564. The second point, it's not just the error on count one. 5 times the judge uses official act when talking about the bribery count 666. No jury would reasonably think there was any quo for them to analyze if the judge had just directed a verdict on official act. So vacature is needed in a new trial on both. My third point, Your Honor, is I ask you to go to the Jennings decision. Judge Michael, 1998, for a unanimous panel. He says, quote, and this is a case upholding a 666 conviction, quote, the gravamen of a bribery offense is a payment made to corruptly influence or reward an official act. That's 160 F3rd at 1020. To be sure, the court didn't have in front of it in 1998, what are the constitutional bounds of official act? Judge Michael for the court uses the term official act at least 24 times. Why? The natural understanding of the quo in a federal bribery statute is that you need to show an official act. Ms. Ray says that 6 courts of appeals have ruled to the contrary. Not so. Let me start with Reichberg. That was the subject of the 28J the government filed last Friday. We responded on Monday. In Reichberg, there was a bribe made in part to seek a promotion or transfer of one of the police officers. So Ms. Ray seizes on that, an employment action. The person that the defendant wanted promoted or moved was the person to whom he was paying the bribes to grant gun license applications and to release arrestees from custody. That's a wholly different case than this case where Ms. Walker says, I didn't know these people. There was no ask of me. I was not asked to do anything inappropriate. If you look at the other cases, Your Honor, every single one, if you end up employing a limiting instruction of official act of 666, it wouldn't disturb the outcome of any other court of appeals. They involve awarding contracts like Eng in the Second Circuit, Repack in the Third, Porter in the Sixth. Porter had a 2-sentence analysis saying we reject the notion of an official act element and said that those words aren't in the statute. But the same could be said of the honest services fraud statute as well. Henderson, the other case in the 28J, was about not reporting someone with contraband so that they wouldn't have to face a disciplinary proceeding. This is the only case in the federal courts of appeals. May I finish?
You may finish.
Thank you. This is the only case in the Court of Appeals post-McDonnell where a campaign contribution was given for a quo that did not seek an outcome on a matter seeking a decision, an agency determination. And for that reason, we urge you to reverse and enter and return for a judgment of acquittal to be entered, but at a minimum, give this case to the jury on both counts so that they can decide whether there was an official act here on counts 1 and count 2. Thank you, Your Honor.
Thank you, Mr. Rubin, Ms. Ray, for your excellent presentations on these very difficult and important matters. We'd love to come down and shake your hand, but under the circumstances, it's for your benefit and ours that we don't. But know nonetheless that we really appreciate your being here. We Wish that you'll be safe and stay well. Thank you so much.
We appreciate it. Thank you.
Good to see you. We'll ask the
May it please the court. Pardon me. My name is Paul Gill. I represent appellant Anthony Peters in this appeal. There's no question under the law that what starts as a consensual encounter between police and a citizen can develop into a Fourth Amendment seizure that is unlawful absent reasonable articulable suspicion of wrongdoing. If the circumstances would indicate to a reasonable person that he was not free to leave.
Let me ask you this, Mr. Gill. As to that memorandum of understanding, is that what gives the police their authority to do their patrolling in that area, or is there something inherent other than the agreement?
Judge, I think the answer is yes, that gives them that authority. I don't think that necessarily trumps state law on what constitutes a trespass, things like that. But that is certainly something that informs their ability.
Well, let me ask you about the extent of that. It appears that this encounter occurred on a sidewalk. Is that sidewalk part of the housing authority's property, or is that public property?
Well, Judge, I think that's an interesting question for two reasons with respect to sort of the notice of the sort of trespass notice that has to be required and what the record reflects here. Judge Hudson at Joint Appendix page 117, I believe it is, specifically asks of Officer Butler, the lead officer in this case, are there any signs along the walkways or roadways that place any restrictions on people being in the area? Officer Butler responds, no, there are no signs, no, sir. And in fact, if one looks at especially the first, I would say maybe a minute, 30 seconds to a minute of the video, which is the body-worn camera video that is relied upon by the district court, is on the chest of Officer Cooper. And as that pans around, one can see the front, sides, and backs of a lot of different buildings at the complex, and there's no indication of any signs on there. I think Judge Hudson was concerned enough about that issue to, again, because the video was played during the hearing, to ask specifically the question, and again, the answer of the officer is there were no signs on the sidewalk, which is where the defendant was seen, or elsewhere, really. He doesn't describe actually seeing that there are still notice signs up there.
Well, the trespass that we're talking about in this case is trespassing once vanished, right?
That seems to be the implication of his repeatedly saying, you are barred. Yes, sir. Again, as far as when this occurred, I would submit there's a seizure long before officers do physically grab Mr. Peters, take him down, search him, and find the firearm on this person that leads to this case. For talking purposes, I would say if one just looks at the first 90 seconds, clearly that reflects a seizure taking place. What happens in that time is that officers are closely flanking. Again, I think both the testimony and the indication from the video are that the two, essentially, the defendant is at one part of a triangle, the officers are at two other points on the triangle, and are within about 5-6 feet, I think is what some of the testimony says. And again, it's consistent with what's on the video. In addition, there is about maybe 15-20 feet behind Mr. Peters a building from Creighton Court, and he is actually standing near the end of a ramp with a handrail leading down toward the sidewalk where Officer Butler is. In those first 90 seconds, he's accused 5 different times of criminal trespass. He is threatened with arrest for trespass. He is asked or commanded at least 8 times by voice or gesture. When I say gesture, there is actually one point later on where Officer Butler makes this sort of lifting one shirt motion, and he makes it like 6-7 times in a row. The officers are doing nothing to further their investigation of trespass, and again, they are in a development where even the court recognizes there seem to be no signs visible or no signs indicating sidewalks and roadways are part of the trespass ban. Judge, Your Honors, there's obviously a lot of case law about how words alone may be sufficient to convert a voluntary stop into a seizure. That includes the Richardson case from the Sixth Circuit, which was cited favorably by this court in the Jones decision. In Jones, one of the things that the court found important in Jones has some application here. In Jones, the defendant himself described the situation as it wasn't like the officers were saying, hey, how you doing? It was lift your shirt, can I pat you down, from the very beginning. And again, that's consistent with this record, both in the first 90 seconds and for about another 90 seconds or more before the leading to the physical seizure. Black and Weaver are decisions from this court cited in my brief that kind of go over more broadly the kind of factors that go into this Mendenhall seizure equation. They include the number of officers. Of course, there were two here, whether they were uniformed or not. They were both uniformed. Whether there were weapons involved, both officers were armed, but the firearms were holstered. I will say, if one views that first 90 seconds or continuing on, Officer Butler, who is the officer visible, obviously, from Officer Cooper's camera, Officer Butler does spend a lot of time with his hand sort of on his belt, which is pretty close to what I've certainly heard in many cases described as sort of a ready position on the firearm, but he doesn't unstrap it. He doesn't actually retrieve it during this encounter. There's the Butler-Weaver factors also include any attempt to physically block departure. There is certainly not a more definitive act like blocking in a car on a roadway. That doesn't exist here. But again, as described, he is flanked by two officers who are very close to him, and on either side, there is a building right behind him. Officer Butler to his just off to his right, as well as the guardrail leading up the ramp to that building. And then, of course, when it does come to language, it's not simply the words that are used, but it is how often they are used and the language or vocal tone suggesting compliance might be compelled. I think the best description I can give to much of the wording, I can't add to the wording that one hears on the video or sees on the video, but is that it is both persistent and frankly presumptuous and a little mocking at times. Of course, there are accusations that he is barred and arrestable. There is a very strange moment where, and again, the officer spoke about this a little later, but he engages in what he describes as a bucking maneuver, just sharply jumping forward as if he's going to go toward and do something to Mr. Peters. And Mr. Peters does not react other than with some sense of amazement. He goes, what are you jumping out at me for? What are you doing? The officers, of course, the way they're saying things, they're saying, just lift it all the way, man. Hey, man, just do it. So you're fine if he pats you down. So it shouldn't be a problem. So again, this is just like Freddie Jones said in the Jones, you're barred, you're trespassing, you're this, your suspicion of wrongdoing existed. I'm happy to go over each one of those individually. I will say, as a general rule, I don't think any case cited by the government, this is preceding, this is at the time of the stop, not at the time of the takedown later, but, his response was, no, that doesn't seem to be consistent with what the lead officer's testimony was. The government also were no suspicion.
Mr. Gill, isn't it true that Officer Butler stated his reason for what he was doing? He was investigating a trespass, nothing else.
That's true, Your Honor. Yes, and that sort of leads me to the last point that I think the government makes with respect to the issue of whether it was reasonable whether the reasonable suspicion. The guy indicated Peters was selling in a specific address. 2, he had provided reliable information in other cases, and 3, that the stop occurred in front of the house. He wasn't investigating Peters that day for possible drug trafficking, to your point, Judge Floyd. He didn't have enough information to believe whether Peters was engaging in drug trafficking in Creighton on that day. And other than I think he described it as a record management alert data from 2009, he had done no independent corroboration of the confidential informant's claims. In addition, the claims of what the confidential informant said do not indicate that the informant claimed the defendant was armed. In addition, there was no evidence that the confidential informant had been determined reliable as to the claimed illegality. I think I've addressed this fully in my briefs, but Bumpers, the 2013 decision of this case, involves essentially the prompt scattering of the defendant and a fellow loiterer on a clearly no trespass signed store parking lot upon seeing police. We have none of those factors here at all during the duration of this report. Judge, I see that my time is, I think I see that my time is up.
You see correctly.
All right, I apologize, Judge. I'll be seated.
Good morning, judges. I am Stephen Anthony with the U.S. Attorney's Office. May it please the court.
Yes.
Despite having information that Mr. Peters was unlawfully present in the Creighton Court area, that he had engaged in drug trafficking in the building where he was seen walking in front of, despite knowing that he was also with a non-resident who was also barred. What Officer Butler and Officer Cooper intended to do was engage in a consensual encounter with Mr. Peters and Mr. Garrison to inquire about why they were present in the Creighton Court area. And so they did that when they got out of their vehicles and they asked both Mr. Garrison and Mr. Peters, basically, what are you doing here? As they both continued to walk, Mr. Peters and Mr. Garrison, the officers also asked them whether they would lift their shirts to show that they didn't have any weapons. Mr. Garrison did so. He raised his shirt, as you will see in the video, above his waist. I think he actually even exposes some of his skin at one point, and he continues to walk. Mr. Peters slightly raises his shirt, not above his waistband, and then he makes the choice to stop and talk to the officers as they continue to ask, could you lift your shirt? At no point during that initial part of this encounter did either officer say, stop, come and talk to us, don't move, any sort of command to dictate to Mr. Peters that he should stop and talk to them and has to stay and talk to them, or otherwise make him conclude that he could not freely go about his business. Indeed, Mr. Garrison, who was also being directed with the same questions, who was also facing the same questions from the officers, continued to walk and then left the area and they had no other encounter with the police, as far as we know, that day. So with that, judges, what I think we need to discuss, and I intend to discuss first, is why this was a consensual encounter between Mr. Peters and the officers. Not the least of which is that a reasonable person, Mr. Garrison, found it possible and indeed did leave the area. Secondly, in the alternative, if the court does determine that this was indeed a Terry stop, one needing to be supported by reasonable suspicion, that there was indeed reasonable suspicion by Officer Butler that Mr. Peters and Mr. Garrison, for that matter, were trespassing, and that Mr. Peters, in fact, could be armed at the time that he was encountering the officers.
But how old is that information? That arming thing occurred in a report that's 10 years old. And he was trespassing. What information does he have currently?
Judge, I think
what he does have is Peter saying, I've just been in my family's home.
Yes, sir. There's a couple things. One, I think also requires me to address a question you posed to Mr. Gill, which was whether this was only, this trespassing investigation was only based upon trespassing after being banished. And I think that's incorrect. When the court looks at the memorandum of understanding, which is at Joint Appendix page 247, the officers are tasked with investigating any issue of potential trespassing where the person is a non-resident, is not accompanied by a resident, is not an employee, and may be there with no legitimate social purpose. So what we have with Officer Butler, is not simply that he knows that there was a 2011 arrest for trespassing from which he concluded that Mr. Peters was barred, but we also know that he's not a resident there. At least as far as Officer Butler had information, the residence of Mr. Peters was in Mosby Court, which is not within Creighton Court. So he's not a resident. He certainly has no information that he's an employee. Then he also knows he's not being accompanied by our legal resident because he knows that Mr. Garrison is also barred.
Wouldn't that be the same description of me going to Creighton Court? I don't live there. You have no information that I have in the business. Would that be for me or anybody else?
It could be, Judge, at the threshold level, but I think the difference is all of the information Mr. Officer Butler knew about Mr. Peters beforehand.
And that's 10 years old.
No, it wasn't 10 years old. The fact that he was there with a non-resident and was not a resident, that was current information.
But he was with someone who was not a resident?
That's correct.
Well, that's the same. Well, then the person with me also is not a resident. Wouldn't I be in the same position?
But again, I think the difference is it's what the officer knew about Mr. Peters versus somebody else he had no idea about. So if there's someone in Creighton Court walking around that this officer does not know at all, then yes, it would be different for him to say, well, let me stop that person and inquire about whether they live here or whether they don't, whether they're with somebody who lives here or they're not, whether they have a legitimate social purpose. That's the Jones case. That's the case where the officer says, these are 4 Black men in a vehicle I don't recognize. I don't know them. Let me stop them. That's not the case here. Yeah. What the case here is this is Anthony Peters and Gregory Garrison. These are 2 people that Officer Butler has encountered and knows. Officer Butler knows neither one of them lived there. Officer knows that Mr. Peters at least has this prior arrest. Officer Butler knows that he has information from a confidential informant that Mr. Peters sells crack cocaine in Creighton Court.
But that's not what he said. The whole stop was trespass.
That's correct, Judge, but that also feeds the trespass question, right? If you're there in an area where I believe that you might also be selling drugs, I can also believe that you may not have a legitimate social purpose for being there.
But that's the problem. All those things you talk about, you can believe about a person exists for the universe. That's the whole idea. You can't have a drag net that's so broad that it gets a lot of people. You don't know anything about me. He wouldn't know about me. I'm walking there. Maybe I don't look like somebody who lives in Creighton Court. Why couldn't they say, well, you know, he doesn't look like he lives here. I don't see him with anybody who's there. And lift up your shirt. So then I would have to comply, right?
No, sir.
Why not?
Again, the point is, it's not that he doesn't know anything about Anthony Peters. Yes, he does not know anything about Judge Gregory. If Judge Gregory was in Creighton Court today, and Officer Butler encountered you and obviously didn't know you were Judge Gregory, no, he wouldn't know anything about you. He wouldn't be able to just stop you randomly and say, would you lift your shirt because I'm investigating trespass? That's not the case with Mr. Peters. He knows Mr. Peters. He knows Mr. Peters has a drug trafficking history. He knows Mr. Peters has his
No, he doesn't know that. There's nothing in this record that has validated any reliability on that CI at all in this record. That's that you can't make the record what it's not. It's just at best it's an allegation. Nothing was done. That's undisputed in the record. The point is the dragnet is so broad. And you said that this was just voluntary. Didn't they come out? Didn't they stop the car in the street?
Yes, sir.
They just stopped it right there. They came out and said, within 20 seconds, you know you're trespassing. You shouldn't be. You know I can arrest you. Does that sound like just a friendly conversation, consensual? 2 police officers flanking me, telling me, you know I can arrest you for trespassing. And then to buck at him, what were they trying to do? Get him to provoke him to act like, to hit them or run or what? What was that for?
Judge, there's a number of things you raised. I want to address all
of them. Raise the trespass. That's what the only reason when this record said he stopped him for.
There's a number of things you raised I would like to address. First, as a factual matter, with respect to the officers getting out of the vehicle and within 30 seconds threatening to go to jail. That is not the case. What happens is Officer Butler gets out of the vehicle. He first addresses Mr. Garrison. He says, hey, GG. And then he says, you know you're not supposed to be out here. Neither one of you is supposed to be out here. You're barred, right? So that is a suggestion or a implication that he thinks that they are trespassing. Yes, that is correct. But again, we have to consider a reasonable person situation and what happens in this situation. In this situation, both of them continue to walk initially. Both of them continue to walk away even after the officer asked them, can you lift your shirt? Mr. Garrison not only continues to walk after lifting his shirt, He continues to walk out of the scene. He's gone. Mr. Peters stops and talks to the officers. That's why it's a consensual encounter. It's because Mr. Peters said, I'm going to stop and I'm going to talk to them. And as they're talking to him, yes, they keep asking him, can he lift his shirt? But again, if an officer is in a consensual encounter with you, he can ask whatever he wants. And at some point you can say, I don't want to do that and continue to walk away. Mr. Peters never does that. He never takes the tack of Mr. Garrison. He stays there. The other thing the court mentioned is about the CI information and whether that was a reliable CI.
No, it's different. He complied with what the police officer wanted. Then he walked away.
Yes, sir.
That's different. No, he lifted his shirt up. Then he walked away. That's a clear indication. Unless I do what you ask, I can't walk away like he did. So that's a distinction right there.
I think that the reason why that's not a distinction, Judge, and this is a point Mr. Gill brought up a couple of times in his brief. He kept bringing up, well, they couldn't see the front of Mr. Garrison's shirt or the front of Mr. Garrison's pants either because he had walked past them by the time they asked him to lift his shirt, implicating that they were somehow focused on Mr. Peters. But if you look at it the correct way, I think you should look at it, despite the fact that they didn't see Mr. Garrison's shirt, the front of his shirt, he kept walking and they didn't pursue him and say, oh, turn around, let me see the front. You didn't show me the front. They wouldn't have said the same thing to Mr. Peters, except Mr. Peters stopped and became evasive and he would lift it slightly or slightly a little more. And then they was like, well, can you lift it all the way up so we can see? That's why he kept getting the questions. Mr. Garrison stopped getting those questions despite not showing the front of his pants because he kept walking.
Anthony, this encounter started at 22.29.31 seconds. At 22:30, the officer says, so you want me to take you to jail? Within 1 minute. Where's the reasonable suspicion? Engaged in criminal conduct.
The reasonable suspicion there, Judge, is that he is engaged in a trespassing violation. And again, what the officers are tasked with, as we look back at the memorandum of understanding, is not just whether somebody had been barred and was back on the property. They also had the power and duty to investigate whether the person was a resident there, whether the person was with a resident there, whether the person was an employee there, or whether the person had some other legitimate purpose to be on the Creighton Court property. Once again, if I could go back, Judge Gregory, to the points you made about the CI and whether the CI was reliable. Yes, the record does reflect there was significant points as to why the CI was reliable, not the least of which is that the officer had relied on his information to make arrests. The officer had relied on his information to do controlled purchases. The officer had relied on his information that led to convictions. All of that is in the record, and all of that is what Officer Butler testified to. Now, with respect to the trespass itself, going back to Judge Floyd's question, with respect to the memorandum of understanding, all of those factors that the officer is investigating, all of them weigh against Mr. Peters at the time the officer made the contact with him. He was not a resident there. He was not accompanied by a resident there. In fact, he was accompanied by someone who was also barred. He was not believed to be an employee there. And then with respect to the legitimate social purpose, that's why we have to take into account what the CI brought up. Because what the CI said was the reason, or one of the things that Mr. Peters is doing while he's in Creighton Court, a place he doesn't live, a place where the officer thought he was barred, is he's selling crack cocaine. And he's selling crack cocaine in a particular building. And as the officer was coming upon Mr. Peters was almost nearly in front of the very building where the CI said, yeah, he sells crack out of that building. So that's the reason why he wouldn't have a legitimate social purpose. And that's why the officer got out to speak to him. Now, what the officer didn't do is say,
so wait, I'm just saying, all of you're saying, and none of that's in the record, because the record says exactly what the reason was trespassing. Now, you're saying this, and that, I mean, it's been a great jury argument, but it's not what the record is.
Judge, the record does say that the officer...
I thought the record said the reason that he stopped him was to investigate trespassing.
That's correct, Judge.
And nothing about drugs or being at the same location where the CI said that he slings or that kind of thing. You're saying that, but that's not what he said.
Because the testimony of Officer Butler specifically makes reference to the fact that the CI gave him information that the defendant was selling drugs out of a building the building where he was stopped right in front of.
I know that. That's why we know that, because he said that that's what he had been told. But the question is why he was there and why he made this encounter with a citizen. That's the whole idea. The Fourth Amendment protects citizens. Now, it's not about whether or not you judge the quality of the citizen or where they are, what they look like. The question is, he's there for the trespass. Then you said he was trespassing?
Well, for the reasons I just listed under the memorandum of understanding, yes, he was trespassing. He was not there as a resident. He was not with a resident. He was not an employee. And again, what the point I'm trying to make, and if I could isolate this with respect to that one issue of being there with a legitimate social purpose, that's the reason why the allegation of drug trafficking is so important.
So I can't walk on the sidewalk of Creighton, because I know the area very well. It's a sidewalk that abuts a public street. I can't walk on the sidewalk because I don't live in Creighton Court? Is that what you're telling the court?
That is not what I'm telling you.
I didn't think so. Well, then he was on the sidewalk.
What I'm telling the court, well, let me also address that in the record. If the court looks at the video, at the very outset, Mr. Peters is not on the sidewalk. Mr. Peters is on the grass. Mr. Garrison is on the sidewalk. So that's one distinction that's important. But beyond that, Judge, what the district court found, and I think it's a factual point at this stage, is what the district court found in a footnote. It mentions that the apartment complexes of the RRHA, the complexes are restricted areas where the memorandum of understanding applies. And if the court is familiar with Creighton Court and similar courts, Mosby Court, those courts, they have apartment buildings on either side of streets within the complex. So it's as if you're going, for lack of a better term, going into a subdivision. It is not simply driving down Broad Street and there are cars or houses on each side. This is a particular street within the complex where apartments are on each side and there's no trespassing in the complex. And so what the officers are enforcing is not simply somebody not belonging in a building or not belonging on the grass. What the officers are enforcing is somebody being in the complex that doesn't belong there. And again, I think the distinction between somebody the officer has no idea about versus somebody the officer knows is what makes this case distinct. This court doesn't have to issue an opinion that anybody going into Creighton Court that is not known to the officer can be stopped. What we're saying is that somebody the officer knows and knows about and knows what he might be doing while he's there, that person can be investigated for trespass. And that's what the officer did here. When he confronted him, he had the information of a prior arrest. Even if it wasn't a barment and it didn't result in a conviction, even if he was wrong about that, what he still had is that he's not a resident, he's not with a resident, he's not there as an employee, and he's not likely there for a reasonable, legitimate social purpose because we know, or I know as the officer, I have a reliable, confidential informant that tells me he sells crack out of that house. And he's in front of that house where he's supposed to be selling crack. That's not a legitimate social purpose. That's why this is an investigation that was proper for this officer. Again, this is not Jones. Jones was 4 black men driving down the street. And the officer said, I don't know them, they must not belong. And then he proceeds to follow them from public property onto private property. And then he blocks them in. And then he goes straight to the one driver and says, lift your shirt. That's not the case here. There is no following. There's no blocking in. There's not following an unknown person onto private property from public property. And the officers didn't go any more towards Mr. Peters than they did towards Mr. Garrison. They went towards both of them with questions. The difference is one chose to stop Mr. Peters. Mr. Garrison chose to keep walking. There's no reason to believe that if Mr. Peters did that there would have been a chase or otherwise the officers trying to stop him any more than they tried to stop Mr. Garrison. And insofar as Mr. Garrison is a reasonable person, or we can presume that he's a reasonable person, the reasonable person would have reason to believe that he could depart that encounter. Now, with respect to the reasonable suspicion that Mr. Peters was armed, we are not focusing on any single factor. What we have here, again, starting with what the officer knew beforehand and what he gleaned while he was encountering Mr. Garrison. Mr. Peters. What he knew beforehand is that Mr. Peters had these alerts, and we don't have to put a lot of weight in those alerts because they are in fact old. But one thing to consider that despite the age of those alerts, what the officer had is fairly contemporaneous information that corroborated those alerts. What was that contemporaneous information? The CI said, I know Anthony Peters is selling crack cocaine in Creighton Court out of the building where the officer saw him. Officer Butler specifically said that in his 6 years of experience being in Creighton Court, he knew that drug trafficking and armed drug trafficking was prevalent. And this court knows and has said many times that drug trafficking and guns go together. All of that informed him even before encountering Mr. Peters. And when he did encounter him, what he found was Mr. Peters, I'm out of time, Judge.
You can go ahead and finish it.
What he saw is Mr. Peters being very evasive in terms of wanting to lift his shirt. And so as the officer's keeping his eyes on a particular area of his body, once Mr. Peters finally lifts his shirt above his belt buckle, the officer says, that looks like a muzzle, and you see the officer go in. So, Judge, for all these reasons, Peters was armed of investigating trespass and other crimes.
All right. Thank you, Mr. Anthony. Mr. Gill, you have some time reserved.
Judge, I think I'd address 3 points. One is the supposition that the officers intended a consensual encounter. I think one knows someone by their deeds, right? Not by their words or intentions. You glean intentions from what they do. And what they do is they come on up, they stop quickly in the street, they get on out, and they immediately accuse Officer Butler in specific, immediately accuses both of being barred. So again, that is as this court has repeatedly said, that's not the typical voluntary police encounter that starts with, hey, how you doing? Mind if I ask you some questions? It's accusations of wrongdoing from the beginning. The second thing I'd say is with respect to the investigation of trespass, there really was, as far as I can tell on this record, no investigation of trespass after my client stopped and looked at the officers and had the dialogue he did. That is to say, Mr. Peters actually says, I am not barred, denies it, says, look it up. There's no effort to do that. There is no effort also, there is no questioning saying, who are you here to see? What's your business here? There's no suggestion like that. The other thing is I do go back on the third point to what the record was and Judge Hudson's concern that I think a valid concern that he really, whatever the memorandum of understanding says, he can't see on the many buildings displayed in the video any signage at all, much less any signage, which he specifically asked Officer Butler about, saying it's unlawful to even be on the roadway or the sidewalk. I think those are significant, and I think those deal with the government's reliance on those points.
All right. Thank you. Thank you, Mr. Gill and Mr. Anthony, for your presentations today. We'd love to come down and shake your hand, but we can't under the circumstances. But please know that we appreciate your being here, and we wish that you will be safe and stay well. And with that, we'll ask the clerk to recess the court for the morning session.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.